We have Gönenç, Gürkaynak. Hi, Gönenç. Sorry for my pronunciation.
Good.
You're a partner in a law firm in Istanbul. I won't try to pronounce the name of your law firm. Excuse me for that. Again, we are focusing here on regulation of generative AI and AI in general by competition law. But I would like to ask to the panelists now, what are the challenges for competition agencies to address that kind of problems? May I ask you, Gönenç, to elaborate on these challenges for competition agencies, and to answer this question, is it a good timing to intervene in the market?
So the good timing is a question of human existence on the world, really, because we're talking about a concept that has been introduced in one lifetime of humans, and we should always remember that. So 1940s, you didn't even have the terminology of AI. 1950s, only very few people might talk about it. Then it developed in 70s, people disengaged from it. So AI went into a freeze. It was sci-fi, no one cared about it. 80s, first half of it, still no one. Then started again, and now today, suddenly, with the push of 2000s and 2010s, especially the pop issue of the chess match with Kasparov and everything, which we don't even consider to be proper AI today, we're now looking at $110 billion per year investment by private entities market. So we may be quick to want to regulate it. It may be a correct reflex because there might be a tipping point, and it may be reinforcing the existing dominances, especially the capability to process big data may bring with it opportunities of discrimination and some other ill will. But it may well also be correct that we might be reacting to what we don't understand in such a way that we're stifling it.
Mm.
In 2016, I published an article with Computer Law and Security Review of Elsevier, and it was called Stifling Artificial Intelligence, Human Perils. And I was trying to explain 8 years ago that jumping on it too much without understanding it enough is as bad as not regulating it. And I was trying to give concrete examples of what might happen. Obviously, it's difficult to advise baby steps because while it's easy to control for the results of baby steps taken, and it reduces the possibility of perverse enforcement, it also brings with it inadequacy. If you're taking baby steps and if the technology is growing exponentially, then you're finding yourself in a situation where you're going to necessarily come up with under-enforcement. But to avoid under-enforcement, if you up it too much, especially in certain spheres of competition law, you might be doing something wrong. My take on it and my overall mapping on it is roughly that whenever we're talking about the potential to facilitate price collusion, we can aggressively regulate. It is difficult to have a wrong perception of regulation with it. We understand what we're regulating. We understand what we do not want. So facilitation of pricing collusion too effectively through artificial intelligence is something we can regulate. Be it through hub and spoke, i.e. competitors using the same AI, be it through the predictable agent problem, meaning AI acting so predictably and AI understanding the predictable nature of the other AI that they're all colluding without, there being the intention to do so, or even through a tad more sci-fi understanding of it up until years ago, but now it's very real, which is that AI becomes so sophisticated that it sees as the superior choice collusion because its mandate is to profit maximize. and the necessary guarding principles are not introduced into the algorithm. And that should be the responsibility of the people who are coming up with the AI. But we're comfortable in this zone. But when it comes to the potential to facilitate behavioral discrimination, then it starts getting a bit murky, because there is a particular output that we're getting from AI that we were unable to get as well. So yes, an incumbent entity that is using AI very effectively is addressing each singular customer in a way they were never addressed before, and that's raising the entry barriers, and it's difficult to match as a performance, especially if the holder of the algorithm also holds the data. But at the same time, the consumer is getting something out of it that was unheard of. So there, we're not as smug and comfortable as our regulation of the collusive behavior, and we have pros and cons and rule of reasons, and should we not, what's happening here? We need to understand the technology, and that mandates baby steps. Only there's always, I don't want to use the T word here, but there's always going to be the worry of tipping happening. Tipping is coming. Oh, we need to do something. Yeah, it's true. But at the same time, the fear of tipping and the tipping point of the industry may lead to over-enforcement, particularly in this field where there might be some juice that we may be getting from AI that is really consumer welfare maximizing, if it's regulated in a balanced manner. And then, of course, there is then the issue of the self-preferencing that is brought by algorithms. I think it's now quite clear that to the extent we understand self-preferencing as what traditionally it is, and we were having this conversation at the coffee break as well, it's easy to regulate that one, and it's not that new a technology. While we like to employ the vocabulary self-preferencing, this is an animal we know from the past days of competition enforcement. But when we come into more nifty theories of AI-specific theories of harm, such as such effective matching of the competitor pricing enabled by AI, that the competitors may be dissuaded from coming up with low-cost, low-priced products, because they know already that they're going to be matched immediately, and they won't even have that time period where they hit the market and the incumbent is too smug and doesn't even care about it, and they sweep, they do the first recoupment, and then starts competition. This is not going to happen. They see that it's not going to happen because the algorithm is there, and it's so effective that they never bother. Now, it's interesting when it's articulated, and it sounds plausible too. But this is not competition law, for example. This one presupposes too many things. There are too many scaremongering elements in it. And at the same time, it leads to a matching of the lowest price, which is something from an allocative efficiency perspective we would want. So all I'm saying, I guess, is in articulating theories of harm that are particularly designed about artificial intelligence, we should always check if our theory of harm is a fear from AI itself, i.e. AI bringing further market power, which should be okay. Or is it that AI is more than frequently going to engage in abusive behavior, or is going to allow the holder of the algorithm to engage in it? And that's why we're keeping it under the spotlight. That's the differentiation I would make. Okay,
so I have two questions for you. The first one is going back to the question of regulating the generative AI.
Yeah.
If I understand correctly what you said, you think it's maybe too soon to intervene on the market because we need to know more about the market. So what do you think about this argument saying that if we apply this exact same reasoning in the 2000 years, we do not think about the rise of platforms, because at that time we didn't know a lot about the platform. So don't you think that early intervention is necessary in these kind of emerging markets, when even if we do not really know a lot, we need to avoid this tipping problem that you mentioned? That's a first question. And the second question is, if you think that competition agency has a role to play, would you focus more on the structures with merger control, for instance? Or do you think, and that's what you said in your speech, we should focus on behaviors, tacit collusions and things like that? So the first one, about the timing. If we wait too much, the winner is going to take it all.
Yeah. So I'm not categorically saying that it's too soon to regulate. I think it's obvious that regulation has to happen. And it looks like it's following a natural course. I mean, Industrial Revolution brought with it employment laws. And AI revolution, the vocabulary revolution also is featured in our session, is going to bring with it its own regulation. And AI regulation is already happening. On the 13th of March, the European Union has come up with the AI Act. On the 18th of September 2023, the CMA has come up with its report. So it's happening. And I'm not saying categorically this is wrong. I wouldn't. All I'm saying is we need to always remember that there is such a thing as perverse enforcement, too much enforcement. And we should always hesitate while coming up with, so we shouldn't be too smug in our assumptions, is all I'm saying. There needs to be a good understanding of the technology, what it may lead to. Ultimately, it is one lifetime of human beings, and we don't know how many lifetimes human beings have on this planet without AI. 10 years ago, if I said this, I would have been probably greeted by, smirking people thinking, oh boy, this guy is a goner, right? Only 10 years ago, if I said one lifetime of AI and we don't know how many lifetimes we have on this, and now we know for a fact that we really need AI, both to rehabilitate all the problems that we have caused on this planet and also to keep our existence sustainable, potentially by colonizing other planets. And if we have really been too tough too early, we may be looking at sliding doors moments, and we won't know about it, basically. So it's only a matter of balance and having the appetite to do a deep dive without assuming too much is what I'm trying to say. And on the response to the second question, I would say merger control bit is important, particularly in my view, on killer acquisitions, because I think in the pure AI sense, not in the innovation theories of harm sense, but pure AI company getting pure AI company sense, the trend is going to be killer acquisitions rather than the quintessential type of merger control that we're more used to. And that's because AI algorithms show their potential very early, very quickly, and only industry participants understand what's going on way before lay people understand it. So I think competition agencies will need to look into these transactions with more rigor. It's because it's not, as I said in that intervention, it's not very obvious to the lay person, and I will include enforcers into the category of lay persons when it comes to understanding where AI is going to, and clearly I'm not claiming that I understand it either. There is ample opportunity in shaping the landscape while you stay under the radar. We now know this is a possibility from some other markets as well, but AI in and of itself is particularly mystical to the lay people. So when there are complaints about a particular transaction and what it will mean in the future, it's going to be particularly difficult for the competition agencies to cast it aside as, oh, this lacks the econometric analysis, the real theory of harm. It's just 2 paragraphs by a technician in the marketplace and all that. And people hopefully will want to look into it and understand if this is truly leading to a problem. But then it's an issue of standards of proof and burden of proof, as it always is. And I'm afraid without understanding the technology properly, articulation of a killer acquisition
Yes.
is merely scaremongering and it's just
I-
speculative theories of harm. Just
Exactly.
one small
yeah.
additional point, and that is at the expense of agreeing again with Thibaut, which we do a lot. But it's very, very important on the discussion of killer acquisitions to differentiate what is truly a killer acquisition, i.e. one that is done for the sake of ridding the market of a newly flourishing AI product, versus I want this to be mine, but I'm a big player. Now, competition agencies are a bit sick and tired of the big tech companies, and there is emotionality involved. There's no doubt about it. I've been doing work on the field for 25 years now, and everywhere around the world, competition agencies would much rather that a big tech company wouldn't buy this AI. Should it be that company that's buying it? Couldn't there be another way of, yes, okay. But at the same time, the same analysis on the technology itself, the projection of whether this product would make it in the marketplace in the midterm and all that would need to be made, because we're doing a little bit too much of the analysis with hindsight today. We're looking at Meta WhatsApp and we're saying, should this have been allowed when it was allowed? We're looking at Google DoubleClick saying the same thing. Looking at Microsoft LinkedIn maybe saying the same thing. I can come up with very many examples. But there is not enough data that shows what would have happened with WhatsApp or with DoubleClick if that transaction had not happened back in the day. I'm not going to go into the annals of counterfactual analysis and all that, but I think we're a bit too smug these days with not wanting big tech to take it, whereas a lot of good AI products will come about through them acquiring these AI products and making something of it. So we will have to differentiate between the true killer ones and the ones that are whispering life energy into the AI product. On Pierre's question, maybe, I would say, so the question was, to remind everyone, the question is, are we looking at a possibility of a DMA-like AI-specific regulation in the competition law realm? Because some MEPs have been suggesting this. And sure enough, we must be looking at it because there will be no competition law left in the future. It seems everyone is taking one bite from it as, oh, this is very sensitive, or but this is too exceptional to be entrusted to quintessential antitrust lawyers. But truly, this question turns into a question of, do we have the correct tools to deal with antitrust problems in the AI field or not? And apart from three particular topics, I think nothing invites specific regulation in the AI field. Only three issues in AI may invite specific regulation. One is vertical integration specific to AI. One may want to come up with, a sidelining regulation to regulate the issue. Infrastructure services that are maintaining the dominance of players, especially as it relates to AI. It may be easier to regulate the rules of openness and fair conduct than going for enforcement after enforcement after enforcement. And obviously, because once they get to it, there will always be the gatekeeper's idea. The early movers and the incumbents will get particular scrutiny out of all of this. Do I agree with this? I don't. I don't think this should happen. I think we do have the necessary means of regulating AI behavior with what we have in competition law so far. But if there were to be a specific regulation, I'm pretty sure these three topics will be the main topics in there.